Please be seated. We'll hear argument in 21-312, Dillion Gage against certain underwriters at Lloyds.
It please the court, Mr. Levinger will present argument for the appellant. The appellant has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The underwriter's denial of coverage here really turns on two related points. The first is that Dillion Gage would not have shipped the gold coins but for the checks that turned out to be fraudulent. And the second is that the fraudulent checks were part of a sequence of events that led up to the theft and to the losses. These are truisms. I'm not going to dispute them, but they do not trigger the invalid payments exclusion clause here. And I say that for two reasons that basically track the Fifth Circuit certified questions. First of all, the losses had to be consequent upon handing over the property to UPS against the fraudulent checks. And the words consequent upon require a higher and more demanding level of causation that the underwriter simply cannot establish here because of the causal effects of UPS's undisputed shipping errors. Second, and alternatively, even if the checks only had to be the but-for cause of the losses, the UPS's shipping errors were a separate and independent cause of the losses, thus requiring coverage despite the exclusion under the concurrent causation doctrine. I'll start with the first question, whether the losses were consequent upon handing over the property to UPS, because the answer to that is no. And that really is dispositive of the questions put to this court by the Fifth Circuit. The initial question is, what is the meaning and the causal effect of the terms consequent upon? The definition is not really in serious dispute here. Black's Law Dictionary says that consequent means basically the natural result or the necessary effect of something. Merriam-Webster's and other dictionaries say it means the result of. The bigger dispute, I think, is over the causal effect of those words, consequent upon. What is the causal requirement? We agree that it's not proximate cause. They say it's the other extreme, but for, where basically anything can be a cause of a loss, no matter how remote, if it played any role whatsoever. That's the wrong test. They admit on page 18 of their brief that a but-for level of causation is associated with a policy that has words like arising from or arising out of. That's what this court held in Utica National. The Fifth Circuit has held the same thing in the Red Ball case. Those words, arising from, do appear in this policy, but they appear in other exclusions. They do not appear in the invalid payments exclusion clause. And that's important because consequent upon has to have a different meaning and a different causation effect from arising from, which appears in these other exclusions. Again, that's what Utica
Is this a
National
British
held.
form? I noticed that the check was spelled Q-U-E.
Right.
I wonder if we ought to be talking about British usage, I mean, consequent upon.
Definitely.
It's odd terminology, and I wonder if we ought to be talking about the way people speak in England instead of what we think it means.
Yeah, it's a good question, and nobody's really addressed the English definition of it, but I do think it does. I think it was written in England for sure.
Do you know, though, if English law recognizes a strain of causation that consequent upon refers to? Well, because I don't know why you would ever write or sign up for a policy like this that has 10 different variations of the way. I mean, maybe it's good literature, but you've got at least 10 different variations of the way that it talks about causation, most of which don't map neatly onto any causation concepts that we have in American law.
Right.
And so policy, what is the court supposed to do with that?
Well, yet the policy directs Texas law to apply. So we're dealing with Texas causation principles based upon how we define consequent upon.
So why isn't it just ambiguous if we don't have a concept like that in Texas law?
Well, nobody argued it was ambiguous.
Well, but it may be, even if nobody argued it.
It could well be. I think the problem here is we probably know the definition of consequent upon. We would urge that the causal effect of that is some middle ground between proximate cause and but for. The problem really is in applying the legal definition and the causal effect of the facts of this case. And that's where we disagree, and that may be sort of ambiguous. I don't disagree with that. At the very least, I've argued that it could create a fact issue.
But where are you getting your definition?
Well, the definition of consequent comes from Black's Law Dictionary, the natural result or the necessary effect.
But
of
I'm
something.
talking about in relation to our law and causation.
Well, if you think of consequent upon as meaning the result of, which Merriam-Webster says, the result of implies a causation level that I would refer to as a substantial nexus or significant causal link. And I get that from the U.S. Supreme Court case of Pacific Operators, which was interpreting a statute that had the words "the result of," occurring as the result of. And the Supreme Court said that the result of means a substantial nexus or a significant causal link, very much like our substantial factor test. So that's where I come back to the middle ground test, not proximate cause, not but for, not merely but for, but something in the middle, which is the U.S. Supreme Court referred to it as like a middle ground test.
Well,
of
focusing
substantial
on
factor.
the word upon as opposed to consequent, it is the Cambridge Dictionary that suggests there is some temporal meaning there. And so upon, as it means soon, as in, you start speaking upon the light turning green. What effect would that have if we were to give that some temporal nexus requirement here?
Well, I think it helps us because it's consequent upon handing over the property, in this case to UPS, third party UPS, against the fraudulent checks. When Dillion Gage handed over the property to UPS against the fraudulent checks, no loss occurred or was really even likely to occur. And the reason is because Dillion Gage did everything by the book. It waited for the checks to clear the bank before it handed them over to UPS. Importantly, it addressed the packages to the correct home address of the real Dr. Brownland. It wasn't as if Dillion Gage said deliver them to the thief's home. I agree in that case the exclusion would apply, but in this case they addressed them to the correct home address.
Did it supply the shipping and tracking numbers to the thief? To a fraudulent email address?
Well, yes, they emailed.
And that's what allowed the shipments to be rerouted.
Well, what allowed the shipment to be rerouted was the fact that UPS violated the shipping protocol that they should not allow any customer to go on the so-called My Choice system and to reroute it without Dillion Gage's knowledge or permission. They violated that. They were not supposed to do that. And they allowed this thief to turn basically the My Choice, it should have been No Choice, but he was allowed to make it My Choice, and he rerouted it, purely a UPS shipping error. It never should have happened at all. And because of that, he was able to reroute it to the facility. To make matters worse, when he showed up at the facility, they didn't ask for signature, at least not the first time. They did the second time. And worst of all, they didn't ask for identification. So they UPS violated 3 shipping protocols that were in place to disable the rerouting function on the My Choice system, to not ask for signatures, and to not ask for ID. Those are the problems here. Dillion Gage, as I said, did everything by the book. The correct home address, instructions not to release without signature or ID. And it was actually UPS then that handed over the property to the thief. And that, to my way of thinking, destroys the necessary causal connection.
Does it destroy it, or is it a concurrent cause where an excluded and a covered event combined to cause the harm in this case? Like in the Lexington case?
Yes, I think you're talking about the concurrent causation doctrine, and there I think it's fairly clear when you look at the case law and the pattern that these cases fall into. The shipping errors were a separate and independent cause. The cases, to be sure, are somewhat result-oriented. So I've looked for patterns in these cases. How do you distinguish between separate and independent causes versus related and interdependent. And what you see is that in all the cases they cite, for example, the Burlington case, the Traveler's Indemnity case, the Thornhill case, the covered event happened first. That was the typical pattern. The covered event happened first, and it was not independently actionable without the excluded conduct. The classic case, for example, is negligent entrustment, training, or supervision. That's a covered event, but that's not actionable without the excluded event of the negligent driving. That's the way the tort works. So therefore, it's derivative, and it's related and interdependent. Our case is the exact opposite. Our case is like Warlow. I think it's very much like the Wilbrose case and the Guarantee National case, where the excluded conduct happened first, and then you have the covered conduct, and it was independently capable of causing the loss without the excluded conduct. That really is the question. Is the covered conduct of the type that it could cause the loss or is capable of causing the loss without the excluded conduct? And the answer in our case is yes. It's very much like Wilbrose. UPS's shipping errors were independently capable of causing the loss, even with perfectly valid payments. Indeed, UPS's shipping errors had caused losses in the past with perfectly valid payments, and that's precisely why Dillion Gage had insisted on these shipping protocols. And I think very importantly, again, to demonstrate the independence of these two things, the fraudulent checks and the shipping errors were by different actors, different acts, different time frames, different locations. The shipping errors had nothing to do with the fraudulent checks, or vice versa. The fraudulent checks had nothing to do with the shipping errors. One had nothing to do with the other. They are really different and separate and independent.
Did Dillion Gage provide the information to the drawer of the fraudulent check upon release of the goods, handing the goods over to the third party? Did they provide the information based on the fraudulent check to the drawer of the check, who then took advantage of that and rerouted the shipments?
Well, I think there are two answers to that. One is probably more accurately, it provided the tracking numbers to the thief because of the application that he filled out. The application showed his email address, and it was their custom to then send tracking numbers via email to the person on the application.
After the check cleared?
After the check's cleared, right. The second, and I think more importantly, the tracking numbers would have done the thief no good whatsoever. The tracking numbers in and of themselves. Only by being able to reroute the shipments, by doing what he should not have been able to do, which was to go into the My Choice system and reroute the packages from the intended destination, which was the home address of the real Dr. Bramlett, to the shipping facility. He should not have been able to do that. Dillion Gage and UPS had a prior agreement that that function was supposed to have been disabled, and Dillion Gage thought it had been disabled, expected it to be disabled. UPS admitted it should have been disabled, and it wasn't disabled. So it was that event that allowed the thief to make use of those tracking numbers that otherwise would have been of no use to him whatsoever.
If UPS had done nothing at all that was in error, and the thief had still managed to get the package, got it out of the truck or got it off the front porch or something, would the loss be consequent upon the fraudulent check?
I would think it would be a much closer case, because there you've got the loss being the result of handing the property over to UPS acting perfectly properly in all respects, and then somehow intercepting the packages from UPS without UPS's fault. I think that would trigger the exclusion. I do.
Kind of hard to see why it should be in one instance but not in the other.
Well, because in your hypothetical, there's no UPS shipping errors whatsoever. There's no other cause. It's part of the theft. In what really happened, you have UPS shipping errors that caused the loss. Without those shipping errors, think of it this way: the property was handed over to UPS. If UPS had done what they were supposed to do, the property unquestionably would have gone to the real home address of the real Kenneth Bramlett, only Dr. Bramlett could have picked up those packages with the signature and ID requirement. And Dr. Bramlett testified unequivocally, as did his wife, that if they had gotten those packages, they would have returned them either to the police or to Dillion Gage. No loss would have happened if UPS had done what it was supposed to do. That is uncontested, unequivocal, and I think that makes all the difference in the world between your hypothetical, Chief Justice Hecht, and what really happened.
Any other questions? Thank you, Mr. Levinger. We'll hear from the appellee.
May it please the court, Mr. Kimmett will present argument for the appellee.
May it please the court, counsel. Dillion Gage is attempting to take what is a fairly simple application of Texas insurance law and complicate it beyond all recognition.
Doesn't the policy do that for us? It seems awfully complicated. I mean, why are there so many different ways to say caused? And what specifically does consequent upon mean?
Consequent upon means cause in fact and but for, which is exactly what Judge Starr said in the underlying litigation, Your Honor. As respect to the other causes or causation standards used in other clauses, again, if we apply Utica, we are talking about a higher standard in those other exclusions than we're talking about here. In Utica, the court specifically dealt with the question of due to, and in that policy, and said that means directly, and that directly was a higher causation standard than but for. So if we apply the logic and the reasoning in Utica, we have different causation standards for different events.
Why do insurance companies use causation language that doesn't have a precise analog in the law that's being selected?
I'm sorry, can you repeat that?
Sure. Why do insurance companies use causation language in their policies that does not have a precise analog in the state law that's been selected to govern the policy?
I can't answer that one, Your Honor.
It
It
seems like it is ripe for ambiguity and for litigation, because if you do that, then the insurance company is probably going to select if a claim comes in, they're probably going to select the interpretation that favors their side, and the same with the insurer. If it doesn't have a determinate meaning under the law that the contract itself selects to apply. So why shouldn't we just treat it as ambiguous?
Because one, the parties stipulated that it wasn't ambiguous, and two, it really isn't ambiguous. If we go out there and we ask, I was thinking about this and I said, if I went out on the street and I asked 10 people, what does the word consequent upon mean? What do the words consequent upon mean? I think you're going to find out that the ordinary and plain meaning means because of. And I think that's exactly what Judge Starr did here. And that's what we're supposed to be doing, is we're supposed to be applying the wording under every single test in insurance policy cases, the ordinary and plain meaning.
I think if you gave them an option, they might say, I don't know what it means.
Well, okay, you may be right, Your Honor. I use that as a bad example, but what I'm saying is we're supposed to look at the common meaning of the words. And the common meaning of the words is, as Mr. Levinger pointed out, following as a result of, a natural consequence of. If we have to go to dictionaries, that's what we do. But I suspect that when everybody reads this, they know, okay, that's what it means. With respect to, I can't answer for all insurance companies in the world as to why they were to do something like that. I can't answer that one. The reality here is the two issues that we have, again, is the wording is not ambiguous in our opinion. Also, when you look at it, there is no doubt that the ordinary and plain meaning of the words is exactly that. Without the fraudulent checks, Dillion Gage would never have given the coins to UPS. Without the fraudulent checks, Dillion Gage would never have given the tracking numbers to the thieves. Without the tracking numbers, the thieves could never have changed the delivery location. And again, I'm kind of getting into concurrent causation first. But the reality is, going back to the interpretation of the wording, the black letter rule, again, as we all know, is that it has to be the ordinary and plain meaning of the words. The ordinary and plain meaning of the words here, as Judge Starr noted, and as other people have noted, is exactly that. And when we apply the Utica test to these words, there are 6 different instances, as Justice Busby pointed out, where there are different causation standards used in this policy. And that is significant under the Utica test because in those 6 different instances, the words direct or directly were used. Again, applying Utica, that means a higher standard than in other causation wordings. To give effect to consequent upon, we cannot say that it is the higher standard or direct to or directly result of, but has to be the lower standard because if the parties had intended for it to be directly caused by, as a direct result of, if we put the word direct in there, we are also violating the law by adding words. Secondly, if we look back at the Gilbert decision, what this court said in Gilbert is if the parties had intended for it to be a higher standard, they could have and should have said so. They didn't do that here. So again, applying Utica and Gilbert, the plain and ordinary meaning of the words is as a result of, consequent upon, in other words, because of.
What is the effect of the change in delivery address?
I'm sorry, Your Honor, what is the effect?
The change of the delivery address.
Well, the effect is it allowed the thieves to get to their plan A. It allowed them to gain possession.
I mean the effect on your argument.
Oh, I'm sorry. It isn't a separate and independent cause. And the only way that it would be a separate and independent cause, and we have to go back to the undisputed facts. First off, Dillion Gage says that UPS should have gotten an ID and a signature. In fact, a fake ID was given with the original application. And therefore, we have to assume that when somebody physically went to pick up the checks, they wouldn't have provided another fake ID. In the second loss, and there's really only one loss, but the second delivery, for lack of a better term, the thief did in fact sign for the package. So we don't believe that the effect on coverage is relevant because the entire argument that Dillion Gage is making about had UPS done what they were supposed to do, there would never have been a loss, assumes that the thieves did not have a plan B. If you look at the exhibit that we provided, and we call it a timeline, you can see that this is a very, very, very complicated scheme that took place over several months. The thieves found out, first off, that these individuals, the Bramletts, had millions of dollars in liquid cash assets. They then managed to steal their checks out of the mail. They then managed to get their online passwords and get their online bank accounts and move money back and forth. They then submitted an application with a false ID. They then submitted the fraudulent check. You have to wait 13 days for the checks to clear. And then all on February 12th, all of these events happened because of, consequent upon, as a result of the checks clearing. But again, to assume that UPS errors were the sole and independent and separate cause means that the thieves did not have a plan B. It means that going through all of this, they then they call UPS and say, hey, we want to change the delivery location from my house to your location. UPS says no, and the thieves go, oh, darn, we just spent months and all this effort and we got nothing for it. I'm sorry, to me that just doesn't make sense. That's why we say their argument is speculative as to whether or not the UPS errors were even a causative factor of the loss, much less a separate and independent cause of the loss. Did I answer your question, Your Honor? Okay. One of the things that we haven't really addressed with respect to causation, going back to it slightly, is this court in multiple cases has said cause, in fact, is the same thing as but for. And we referred to one of them in our brief, LMB Limited versus Moreno. And specifically it says, the test for cause, in fact, or but for causation is whether, one, the act or omission was a substantial factor in causing the injury, and two, without the act or omission, the harm would not have occurred.
Counsel, did either party suggest to the Fifth Circuit that this should be certified, or was that completely of the court's own?
The court did it on its own, Your Honor. It was never brought up by anybody. So when we look at what Dillion Gage is proposing, the reality is their interpretation of the wording is vague and ambiguous and quite frankly, doesn't provide any guidance to courts and practitioners as to what the middle ground standard is. We're supposed to say it is more direct and more substantial. That's what the words mean. But honestly, I don't know what more direct and more substantial means than what cause and fact already says. It's a substantial factor. And this court in XL Corp versus Apodaca, in Marathon Corp versus Pitzner, and in the LMB case, all gave that definition, saying cause and fact is the same as but-for causation, which already includes a substantial factor in causing the loss.
Aren't we required to credit the insured's interpretation if there's two reasonable ones?
No. I know that has become kind of the standard response, and I'm going to refer to Chief Justice Heck's dissent in Utica. The law has always been that the only time that we give more credence to the insurer's interpretation is when the wording is ambiguous. Over the years, however, it has kind of become, if you have two different interpretations, it's ambiguous, and therefore we rule in favor of the insured.
Isn't that the definition of ambiguous?
Two different interpretations? Only
They are
if,
both reasonable.
only if they're both reasonable, Your Honor. You're absolutely right.
That was my question.
Oh, I'm sorry. I don't believe their interpretation is reasonable, so I hope I answered your question.
But if we were to also decide that your interpretation was not reasonable because the policy uses arising out of, and that consequent upon should mean something different from that because different words were chosen, then what happens if neither side's interpretation is reasonable?
If neither side's interpretation is reasonable, then I would suppose that we would
Should
have
ask
to
the House of Lords, perhaps.
Pardon me?
Should we ask the House of Lords?
Yes.
Can we certify this to?
We can all fly to London because they're
Okay,
letting
England.
people come in now. And we can go to London and ask. I think the short answer to your question is if neither interpretation is reasonable, I believe that there would be found coverage.
There would be what?
Coverage. Because we would have failed to meet our burden that the exclusion applies. I'm going beyond your question, Justice
I
Busby.
appreciate the answer.
But I believe that's what you were asking.
Beginning to see why the Fifth Circuit certified this question to us.
I've kind of gone over all of my arguments. The one thing that I did want to point out is if we actually look at the wording and we actually look at again, this policy contains a buyback provision. And a buyback provision specifically related to the invalid payments provision. And that also is page 2 of an exhibit that we provided to the court. And again, at the top being the exclusion itself, there are multiple instances of the use of the word any. And this court has said on several occasions that any is a broad term and should be interpreted broadly. And therefore, when you're looking at the exclusion and the policy as a whole, you can see that the intent of the parties was to apply the exclusion broadly. Then there is a buyback provision specifically related to the invalid payments. And it says, notwithstanding the invalid payment exclusion clause, it is understood and agreed that coverage hereunder is extended to cover physical loss of insured interest, here are the coins, as a direct result of any fraudulent or dishonest payment. So again, with respect to the buyback, the causation standard is direct. With respect to the exclusion, it is consequent upon. Direct is a higher standard. The only reasonable inference is consequent upon is a lesser standard than direct.
But if we also conclude that it's a higher standard than, but for, because the wording is different than arising out of, how do we give content to something between but for and direct?
I don't know, Your Honor. That's why I said their interpretation is unreasonable because it is so vague that I don't know how we would interpret it not only in this case but in all future cases involving similar language.
Maybe people should pick different language. Yeah.
Well, it may go back to the whole idea that this obviously was written, and I need to point something out here. as you can see, if you actually look at the policy says JLT at the top. JLT is the broker. So one of the issues that people talk about all the time is the underwriters chose this wording. The reality is the brokers chose the wording, and the brokers are the representatives of the insured. And you can see it on the policy itself. So again, when we talk about all the ambiguity should be interpreted against the underwriters, the reality is the policy was written and prepared by the brokers retained by Dillion Gage. Unless there are any more questions, I'm going to give my time back.
Any other questions? Thank you, counsel. Ms. Levinger, you have 5 minutes.
Thank you. So we know that the policy uses the word arising from. We know that means but for from Utica National. Counsel referred to the extinction clause that uses the direct result. Well, that's proximate cause. Courts say that. So we have consequent upon. It has to have a different meaning. And that,
Well, so both sides seems to say it has to have a different meaning, but aren't sometimes words synonymous? In other words, they have the same meaning. They're different words, but they have the same meaning.
Well, they admit that the direct result wording in the extinction clause has to be different from consequent upon in the exclusion. And consequent upon is different from arising from. So we've really got 3 levels there. But for is the broadest. Direct result is the proximate cause, the most stringent. And then we have ours in the middle. To answer Justice Busby's
Why wouldn't
question,
consequent upon just mean as a consequence of?
I think it does mean as a consequence of, and then Black says that means the natural result.
This is one consequence of handing it over as sort of,
Right.
as part of this scheme.
Well, and we need to be careful because they're trying to change the meaning of the exclusion. They say handing over the property was consequent upon the fraudulent checks. That's not what it says. It says the loss must be consequent upon handing over. So they're manipulating the language of the exclusion to pick up, to try to link everything to the checks. Handing over was consequent upon the checks. The tracking numbers was consequent upon the checks. That's not what the exclusion says. It says the loss must be consequent upon handing over the checks to UPS. And to go to Justice Busby's question about 2 reasonable interpretations, we've all cited Utica National. Here's what Utica National said about it on page 202. The court must adopt the construction of an exclusionary clause urged by the insured as long as that construction is not unreasonable, even if the construction urged by the insurer appears to be more reasonable or more accurate reflection of the party's intent, citing another Texas Supreme Court case from 1991. So I don't think there's a tie here, but if there's a tie, it goes to the insured under the language of Utica National.
Justice Busby's question was if they're both unreasonable.
Right, and I think this got close to that by basically saying if theirs is a little bit more reasonable than ours is, then the insured still wins. I don't know about 2 unreasonable ones. I think you're dealing here with 2 different interpretations. I don't know that it's fair to say that either one is unreasonable, although I do think when they say but for, that is unreasonable.
I think your opponent said that if they're both unreasonable, you win.
I think Utica National goes a long way towards saying that, Justice Lehrmann, I do. I come back to the most critical fact in this case, and the most critical fact is at the moment, to take the temporal point, at the moment we handed over the property to UPS against the fraudulent checks, no loss should have happened, or inevitably it was going to happen because we had addressed the property to the correct home address of the correct Kenneth Bramlett. There's no speculation. We're not speculating because he testified, and his wife testified as well, that if they got the check, that if they got the property, the packages, they would have turned them back to the police or turned them over to Dillion Gage. The loss would not have occurred but for the intervention of this rerouting of UPS's failure to disable the My Account function. That was the critical event here that I think makes all the difference in the world. If you think about it in causation terms, I think it's fair to say that the checks maybe gave rise to the condition that ultimately caused the loss. I'm thinking in terms of Union Pump, where the pump fire furnished the condition that ultimately caused the loss, but it was not a substantial factor. And that's the key here. The checks were just not a substantial factor in the loss. It was the UPS shipping errors that made all the difference between the packages either going back to Dillion Gage safely, or going to the Bramleys, who would have returned them to Dillion Gage. In no event would the loss have happened were it not for the UPS shipping errors. So that, I think, answers the concurrent causation question, should the court get to it. Unless the court has any questions, that would...
Any other questions? Thank you, Mr. Levinger. Case is submitted. That concludes the arguments set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.